asked about the position in terms of the proposed or anticipated timescales for the living infected registered. You've explained the position in relation to those currently outside any of the schemes. We've discussed the affected. Can I just turn briefly to the deceased infected? Is there any timescale, assuming you're going to do the same and have a test and learn approach, is there any timescale for when that may start?
As with the previous answer, there is not a timescale at the moment. It is our ambition to open all of those parts of the scheme as quickly as possible, and as before, I'll be very happy to, as soon as we know when they are ready to open, that we will tell people that they are ready to open.
And is the intention to do them one after the other sequentially, or is the plan to open the test and learn phases for all the remaining, or at least some of the remaining cohorts simultaneously, so that you're running them in parallel?
I think some of them will have to go singularly, but I think there is the opportunity to do some of them in parallel as well. And again, we'll explain that as we know what the right answer is. What we're balancing is the amount of development effort, in particular digital development effort, in each of those cohorts. And as each of them builds, we have more of the common infrastructure that sits underneath it, which means that more of them can go in parallel. As we know, we will explain that to people. Yeah.
The regulations, in terms of the process of application, specify, and I'm not currently proposing to put the regulations on the screen, but I will if it assists. So just Regulation 14 talks about an application for an infected core payment must be made by, and then there's certain time periods. An application for infected core payment must be accompanied by evidence, and then that's set out. And Regulation 65 says an application must be made in writing to IBCA by the relevant person in a form approved by IBCA and signed by the relevant person. Now, there isn't currently any application form that is accessible by anybody. There are only the invitations and then the various documents that are filled in. When will IBCA be making available an application form that people can complete?
So we've taken the approach of, as I described earlier, of supporting people to get the compensation that they are due. And we've also, when we did early engagement on user research, one of the things that came through quite clearly was being able to do as much of the heavy lifting for people as possible would be helpful and advantageous. So instead of sending out an application form, what we've instead done is said we will start the claim for you. We will gather as much information as we can to avoid you having to do it. We will accept anything that you provide and want to add or change in there. And that allows us to have a smoother, faster, and less burdensome journey. So it ends up being the equivalent of an application form, but it isn't an application form that we are issuing or sending out to people.
Is there an intention to change that so that there is an application form that people can complete?
We haven't, that is not in our plans at the moment, no.
Is there any reason why, as both individuals and recognised legal representatives have suggested to us, IBCA cannot simply accept pre-prepared applications with an evidence pack, with everything that's required, from those who, at least those who were legally represented through the inquiry and whose legal representatives almost certainly already have all the information that's likely to be required or available?
The first is, when a person begins their claim, they absolutely can send anything and everything that they would like to send to us. So that is accepted and would be well received. And obviously, what we do have to do is we have to build a service that is capable of providing for everybody. So We know a lot of people are represented, a lot of people aren't represented as well. And we have to make sure that our service is capable of providing for everybody. We do, as Sir Robert recommended and the government accepted, we do offer everybody, when they start the claim, the opportunity to have independent legal advice, and that is reiterated through the process of doing it as well. But because not everybody is represented, our service needs to be designed for everybody.
I'm not suggesting there shouldn't be a service that works for people who are not legally represented, but and I've been given some real life timescales by RLRs about the speed with which they have been able to give a package that means the claims manager wouldn't even need to have spent time going through the support scheme documentation to see what is or isn't there. Wouldn't it be sensible for IBCA not just to say, well, yes, you can send what you want when we invite you, but to open up the scheme to say that anyone who, within the cohort, whichever cohort you're currently looking at, anyone who is in a position to do that, yes, send us your completed application form, send us your evidence pack. One of the examples I've been given was absolutely within days because everything was already there. And then it just needs checking by the claims manager rather than the claims manager doing an enormous amount of legwork and their own calculations. And of course it has to be checked. Could you not do that while simultaneously obviously ensuring that you're not closing the service to those who don't want legal representation?
So as I said, when the claim journey starts, everybody is welcome to send that and we do accept it. If we did the way you were describing, we would undoubtedly be prioritising the claims of those who are represented and deprioritising the claims of those who aren't represented. And that, I think, would pose a difficulty in terms of being open to everybody. But everybody who does have that pack, when their claim starts, it is entirely accepted and very welcome for them to present them.
Why would it involve deprioritising the claims of those who are not legally represented? You could continue with an element of random generation, and those who are not legally represented will go through exactly the same process as is currently underway for those who don't want legal support. I'm not suggesting something where you only look at those applications that I've described and don't look at anything else.
Well, forgive me, but we're talking at the moment, and probably for some time, about it doesn't matter how many hundreds of claims managers you have, there's a limit to how many they can deal with at once. And what you're suggesting, if I may say so, is that we would give priority to those who came forward with a legally prepared pack. That would inevitably mean that someone who didn't have that would be dealt with later. So there may come a time when there's so many people available that what you say could work, but I'm not sure it would at the moment, or that my board would consider that to be a fair way in which to bring people forward to make a claim.
You could perhaps have two cohorts again, two teams of claims managers, one who deals with claims provided on that basis, another who deals with claims being operating on the invitation basis.
Well, you could do that, but it would still mean that those who didn't have the advantage of legal representation of the type you describe would be disadvantaged. That's at the moment, people are brought forward on the random basis that you have described. Obviously, the more capacity...
I'm so sorry, I've just realised it's 12 o'clock. The fault is entirely mine.
Yes, we'll take 2 minutes silence. Thank you. Thank you. I'm
So-
told the bells will not be heard easily within this building because the soundproofing is too good.
Sir Robert, my apologies.
Not at all. Mine for going on too far long. No, at a stage when we have, as it were, our full cohort of claims managers, the point you make, if I may say so, might appeal more strongly than I suspect it does at the moment when we're in a beta testing stroke stage.
Can I come to the question of how people are selected to apply? And I should just say, we've heard expressions of distaste for the use of the word invitation.
A point we
Someone
accept.
said to me, it's not a party, so I'm going to try and avoid.
Yeah, and can we apologise for the use of expressions? And of course, we've taken that on board, and we no longer use that ourselves.
Thank you.
And I hope that's going to begin to percolate through to the correspondence.
So what we're told that the process is one of random selection. How does that actually work?
We have a list of those who are registered with the existing infected support schemes. They are put into a spreadsheet, and then a random allocation is generated, which produces the individual cases that we then use to proceed to start the claim.
Now, you've recently introduced a system of giving a form of prioritisation to those within that cohort who are, I think, within the last 12 months of life as anticipated. There will be people in that situation who are not in the current cohort, who are either affected, elderly widows, widowers' parents come to mind immediately, or indeed those who've never been registered with any scheme, never received anything, may have been given such a diagnosis. Has consideration been given to what could or should be done in relation to those people who fall within those descriptions?
Yes, and we introduced the end-of-life pathway because we heard that very clearly from the community about its importance. The design of that pathway is applicable to all of the future cohorts. So as soon as each cohort is available and able to take claims, we will introduce the end-of-life prioritisation route as well. So it isn't in existence at the moment for those cohorts because those cohorts aren't available, but as soon as they are, that will be available to them too.
That will, of course, in all probability be too late for somebody who is currently in a terminal stage. And so... And so I absolutely understand why when you open the cohort, if say you were opening a cohort in 2026, why you would then look at that point to see those who are at that point in time fall within that description. But you're going to have lost, literally, those who will have died in the intervening period. Is that something which the authority could go away and think further about?
Well, can I say that when I became aware that this was the policy choice, I drew to the government's attention the operational consequences of that, which in my view were disturbing. And they are the ones you've mentioned. And I'm afraid it is the... I mean, can I just say at this point, without wishing to express too much emotion, I live every day, not as these people do, but with the awareness that every day we are not paying someone, the chances of someone dying are there. And everyone in our organisation is, from the board down to the claims managers, is fully aware of that. Having said that, we have difficult and almost impossible choices to make. And I have to say, this particular choice is one that I would have hoped we could have avoided, but we haven't. And because that's what the policy is.
So when you say that's what the policy is, that's what IBCA's policy
No,
is?
the policy, the fact that the claim dies with the individual, and at the point, particularly, if I may say so, at the point where, up to the point rather, where an offer has been made and accepted. In other words, the whole process has to be gone through. And I have to declare an interest in that. Obviously, my initial recommendation, which was not accepted by the inquiry, was that estates of affected people should be allowed to make a claim. But that was not the recommendation. It's not what the government decided. But even within that context, there perhaps would have been easier points, from my point of view, at which this could have been placed. And I think we've any right to put that on the record.
And do you mind if I come in?
Yes.
So, yes, we will go away and have a look at it. I should point out, though, that there are, I wish we could open it up to everybody all at the same time. From a standing start in May, we've had to build and we've had to understand where to put our development effort to build it. There are possible alternatives about perhaps just manually working some cases. Obviously, that requires us to be able to understand and interpret the regulations that have been in place, and to be able to put effort onto those. So the point I just seek to make is there are no decisions without trade-offs about how fast we can go, about which elements we do in which order, and those are difficult and complicated decisions, but we will take it around.
In terms of prioritisation, a number of people have suggested to us, and I'm sure have suggested to the authority, that one aspect of prioritisation, rather than random selection, could be, in addition to the end-of-life prioritisation you've introduced, but prioritisation that builds on factors such as age or state of health short of being in an end-of-life phase, or co-infection. Those are examples. Age is perhaps one of the most obvious and easily identifiable and applicable. Has consideration been given to that, and if so, what's the outcome?
So we have considered those points, and of course each element you put in there then requires how do you judge that where people fit in that in the cohort. We heard very clearly from the community about the importance of end of life, and we've invested development effort in that to make sure that happens. We're then on a pathway where we're thinking commit as much resource as we can to process as many cases as quickly as we can. And in doing that, we've come up with our commitment to, with the registered living infected, to start 100 on average per week. And that then allows us to progress. And that's why we've been able to say we think we will be able to start all of the claims of the registered living infected this calendar year. If you then start to introduce different layers within there, you've got to commit resource to assessing whether somebody is in that cohort or not. And then you've got a trade-off between, is it best just to go as fast as you can through this cohort, or should you start to put in different tiers and layers within there, at which you have to assess whether somebody sits in there. Our view at the moment is that we should go as fast as we can, commit all the resources we've got to this, to taking claims, to supporting people to get their compensation due, and then getting them paid. And we think that's probably the fastest route through this. But, there is an alternative that says you could stop and think about how you might brigade it in different ways.
Just wanted to come back to the question, not now in terms of how you receive claims, but the broader question about availability of legal support. Some of the statements that we have received hint at least at there having been a degree of reluctance on the part of IBCA to engage with recognised legal representatives, and less than open arms towards their involvement. What would you say in relation to that? And in any event, what is your current position?
I don't think there's ever been a reluctance on our part to engage with lawyers. I think it is fair to say that we have always been very keen to interact directly with the victims, the community of victims. And it may be, in retrospect, we should have spent more time with the lawyers as well. There's certainly on our part, certainly on my part, been no reluctance to engage with the lawyers, and they've certainly had no reluctance in engaging with us. I think that the resource put into correspondence and replying to letters may sometimes have been demanding in terms of the pressures on what we have to do, and if that's been the case, I apologise. There have been some quite tense commercial negotiations with regard to procurement. That I would understand, but that's not because of a reluctance to engage with the lawyers or to appreciate the value that they bring to this situation.
In terms of the stage at which applicants are advised of their entitlement to legal support, I've certainly been told that the initial approaches, because I'm going to avoid invitation, the initial approaches seen by recognised legal representatives in January of this year didn't identify the entitlement to legal support, and the more recent ones do identify the entitlement to legal support. Are claims managers now trained to ensure that at the very first interaction that they have with the individual, that they spell out that entitlement?
Yes, they are, yeah. And we're very clear that that is an important offer. We've heard that from the community. In terms of our view that this is an important thing, it started with, Sir Robert, your recommendation that it should be provided, which the government accepted. And we've been very keen to. But yes, claims managers, from the very beginning of their interactions with, make sure that everybody is aware that that offer is there. Some people come represented, some people come unrepresented and then choose to have a lawyer. Some people have a lawyer and then decide that they don't want to be represented anymore, and some people aren't represented.
Can I respectfully suggest that your website be updated to reflect the position? Because I looked almost in vain to identify anything about legal support on there. And then if you click a button at the bottom of one of the pages that says help and support, you get through to something which says that the Cabinet Office has agreed to recommendations to provide legal support at certain points. Exactly how this will work is still being finalised. We'll let you have more details. And so, and I make it not in a critical sense, but we've seen examples of lawyers with no relationship with historically with the infected blood community, no relationship with the inquiry, offering no win, no fee assistance on solicitors' websites. And it's obviously vitally important that anyone, particularly those who are maybe less familiar with the history than others, going to your website knows that they can have free legal support and that they're told the critical stages. Would you accept that?
Thank you. Yes, we'll do that.
Just want to turn to a question about accuracy and errors. You all have seen from the witness statements from the recognised legal representatives that the inquiry has obtained that there have been some concerns about mistakes being made. And either they've come to the attention of the recognised legal representatives precisely because they have then checked and seen that there are errors. Those who don't have legal representation won't have had anyone necessarily identifying that. So what is the system for oversight of claims managers to try and ensure that no such errors occur?
Yeah, so I think there's a few things to explore here. The first is that in a test and learn environment, which right at the beginning we were in, the idea is to find out what makes it difficult. and to discover that, and then to put in place things that allow a case to flow. So our early cases were definitely explored in that environment, and that's why you have to start small, because you have to put the safety wrap around it to make sure that is covered and supported by all of the different disciplines within the organisation. Secondly, of all the cases that we have paid, all the claims that we have paid, you will know that we have a internal review that can be asked for, and an appeal that can be applied for if people dispute it. To date, we have had no internal reviews and no appeals. The third point is the regulations, as Sir Robert referred to, are undoubtedly simpler than an individual assessment of everybody's situation, but are still complicated and need interpreting. One of the great values that I think legal firms give is they allow us to have that conversation about, well, how are you interpreting those regulations? And in the correspondence we've had, we've been very grateful to legal firms sometimes saying, I think you can interpret it in this way, and we've changed the result of it. But we've also had situations where legal firms said to us, we think the interpretation is this, and we have actually realised that our interpretation of it was the right interpretation, and we have stuck with it. And I think that's a really important part of the dialogue and the value that they bring. But just to re-emphasise, there have been no requests for internal review, nor of appeal, which suggests to me that in that informal and corrective way, we are getting the right answers.
The problem may be, and I am thinking particularly of those individuals who don't opt for legal support, which is absolutely their prerogative, but they may not identify the mistakes and therefore may not ever think of going to an internal review because they don't know. They don't notice that the wrong date of birth has been given, for example, which is one of the examples pointed out to us, or that the dates have been flipped, so it should be 1975 and it's down as something else. So is there a quality assurance process,
Yes.
is what I'm saying, for the claims managers?
Sorry, yes, there is. So claims management, each of them has a supervisor who supports them. Each of them, especially when they come out of training, has a buddy who's an experienced claims manager who supports them. And as I said, at the point of where we get to making a payment, there is a four-handed check on making sure that it is the right assessment. So at each of those stages of decision making, there is somebody who is supporting them, making sure that they're making the right decision. And then at the end, there's a four-handed check about it being the right decision.
And just in terms of the internal review process, and appreciating this idea that you haven't yet had to use that process, what is it? As in, what is the process? Does it involve an opportunity to make some form of case in person or orally to somebody? Who is the reviewer?
So the internal review is done internally, and it's done by a different person than assess the original claim. We have done the internal reviews ourselves, so we have stimulated internal reviews on the basis of the change in the regulations between the first set and the second set. So that allowed us to review all of those cases and go back on it. I think you're familiar with there was a change in the regulations about the 1 year in the calculation was in the forward rather than the backward, and it had to be reverted. So we used the internal review process to do that. What happens is somebody else who hasn't been involved in the claim at all is asked to assess the claim, and they come to review as to what is the right decision as well, and then we see if there's a discrepancy.
But what you're describing there, I think, sounds like a paper-based exercise. It's not one in which the individual can come, as it were, before you and say, I think you've got it wrong for the following reasons.
It is a paper-based exercise, yes.
Is there anything about that process that is accessible and can be published on the website so that, again, so people understand what the process entails?
I'm sure we could publish that process, yeah.
I've got just two main topics left, and then obviously there'll be a break so that core participants can put forward suggestions of questions. The first is the issue of engagement and involvement. You will have seen from the statements, you will have gleaned from yesterday morning's evidence session, but you will no doubt have picked up from all the things that will have been voiced to you, that there are many who don't feel they are being heard. They feel, and I'm trying to focus here on IBCA because obviously there's a whole bigger question there about the Cabinet Office and engagement with government. But there are still concerns being voiced in relation to IBCA, some perhaps less intense than in relation to the Cabinet Office, that some of the meetings are tick box exercises rather than people actually being heard and having a response. I'm not going to ask about any individual detailed meetings, but given that you know that those concerns have been voiced, what is your response or observations?
Well, perhaps I could start by saying that it has always been my personal commitment and the organisation's commitment to involve the community in everything that we do. Now, I'm afraid that engagement is a word we do tend to use, and I actually don't like it very much because I don't think engagement suggests potentially a one-way process when clearly what we're after is a two-way conversation about what we do. How to go about that is a challenging issue because to take an example in terms of say, our email communication, which I appreciate is only one strand of many things we do, we have been, some people will say we do too much of it, other people say we don't do enough, and so we have to make judgments about that. The meetings we have ranged from, the ones I prefer are in-person meetings in rooms like this where people can talk, where you can actually meet people informally as well, which is useful. To the ones I don't like very much, perhaps showing my age, tend to be webinars online where everything is done via a written question and an answer being given. I'm sure we continually review how we go about these things. And I understand and regret the feeling clearly some people have that these are tick box exercises because they are in fact far from that. I absolutely get that the meetings we have, we are perhaps a little bit less now than right at the beginning. We were asked a lot of questions, a lot of points were being made to us about the nature of the policy and what was going to end up in the regulations, which perforce, for reasons I've explained, we had to say, well, we're referring that to the Cabinet Office. And I can assure you that we did that religiously in terms of the points that were being made to us both collectively. And in relation to matters within our jurisdiction, if you were, I would like to think we have always listened and taken into account what has happened. And I can give some examples. You might want to come to it anyway. One of our other initiatives in relation to involving the community was the appointment of user consultants, which was I freely confess, my idea. It wasn't greeted with universal enthusiasm, but also, and there were concerns, and one of the concerns was how can one person represent the community, to which the answer was they're not meant to represent the community. But we did take on board the fact that this was a bit of a burden for one person, and actually were we getting a spread of views. So for that reason, instead of having one, we've had three. We do listen to issues around, I mean, you've just cited an example. We also have been told that invitations as an expression was offensive, and obviously it wasn't intended to be, and so we now change our language. We asked, and we were criticised for it, I've seen the evidence before this hearing, for asking people for their views on sequencing within the beta testing stage, because it was said it was inevitable we were going to get lots of conflicting views. Well, that is true. But personally, I felt it was much better that we have those views available to us with people's arguments as in favour of this or that, so the board could make an informed decision of its own about what the way forward. Clearly there will be issues, and we may have discussed some of them today, where having listened to people, we come to a decision that some people don't agree with. That's not because we haven't listened, it's because we have reasons. Now, whether we communicate our reasons, okay, that's another issue, and maybe we could do better there. But what I would respectfully, well, firstly, regret the impression if it be one that we think of this as a tick box exercise, but secondly, I'd like to assure people that's not how I see it, and I don't think anyone else in the leadership team thinks so either.
And just almost as an observation rather than a direct question, one of the other themes that has emerged from the evidence to us is sometimes about the quality of communication. One example is people feeling that there was a self-congratulatory note to the, I think, announcement a few months ago about the stage which had been reached in terms of the first few claims. In relation to listening to people, again, it's been suggested to me that I put this as a suggestion to you, that it may be helpful to have a clear communication when issues have been raised, a clear communication through whatever means, your website, your community updates. This is an issue that's been raised. This is our response to it. We are accepting that. I think you're now, for example, going to be sending out your emails on the same day of each week, and that was one of the things that people have raised. Or this has been raised with us, saying clearly so everybody understands, because this is such a difficult scheme to understand. This is not something we can change. These are the rules we're bound by. We have forwarded this to the Cabinet Office, or we've listened, we understand, but we are not going to do it for these reasons. I've been asked to suggest to you that would be helpful in rebuilding trust.
The principle of what you say is, of course, absolutely right, and I would like to think that's what we're endeavouring to do. We have now, triumph of triumphs, actually got our own website, which is something we didn't have until quite recently, and which we are populating. So some of this may be a technical issue. The other thing is that, for reasons I think have come over I'd hope in our evidence so far, people understandably want certainty about matters where, unfortunately, for reasons I hope we've explained, we're not able to give it. So sometimes our communications are may be clear, but they may be vague, to be honest. And that's something clearly we would try and to remedy as and when we can. But of course, our communication should be clear, that they should be understandable, and they should be up to date. You've mentioned it already. We have had the point that we communicated too much in an irregular way. So, for instance, we have started, in relation to announcements about opening up to the next group of people, to tell people, which we've done, we're going to do this on a particular day each week or fortnight, and that was in response to what we were hearing. So I think we do respond to all this, but there is never a point at which we will be satisfied ourselves at the quality of communications we make, and we must always try to improve. But I don't know if David would like to add to that, as he's the chief executive, not me.
It's a very important thing for us to do and to do well, and we welcome all suggestions about how we can do it better. We've had over 175 meetings, either in person or online, with either open invitations to everyone or groups of specific people, and those meetings mean so much to us because they give us very direct feedback and very clear indication of how people feel about things. Our ethos is to be open and transparent, and that's a very important part of what we do. It is also a very difficult thing to do, because often we are communicating about things that we don't yet know, or things that are not what people would like to hear. But we think it's really important, and we will carry on doing that. We welcome all suggestions about how we can do it better.
I want to ask you now to look at a document. We looked at it yesterday with the Minister, but I'm going to ask you to look at it for a rather different reason. Lawrence, it's DHOL 603. It's an email about the significance of a date of the 1st of January 1982 for HIV claims. Now, I'm not asking you about the legal or logical merits, or lack of them, frankly, of the position set out in that email. What I want to understand is what it tells us about the relationship between the Cabinet Office and IBCA, if anything, because this is an email from a claims manager setting out effectively what is the Cabinet Office's legal advice, or some aspect of the Cabinet Office's legal advice. Does the Cabinet Office tell IBCA or seek to tell IBCA or steer IBCA as to how to construe the regulations?
Where there is an interpretation about the regulations, we are always interested in able to interpret it properly, understanding what the government's intent in the regulation were. And that does then mean that we work in a multidisciplinary team on those issues. There's usually somebody from the Cabinet Office. If they feel they need legal advice, they will get from the Government Legal Department advice. There will be IBCA policy officials, and there will be IBCA operational officials. And where we have something that defines how they should be interpreted, or is the key part about interpreting them, we will convey that. We will convey that as an explanation for why that has been the decision.
So, I mean, this has come to light precisely because the claims manager did share it with the individual, or with an individual and their recognised legal representative. Would you agree that if there are particular issues that are arising on the regulations, in respect of which IBCA thinks it needs assistance, it doesn't feel it can absolutely answer it for itself, or that it's not straightforward, that there might be something to be said for not just going to the Cabinet Office, but also publishing something in your updates, or communicating something to the pool of legal firms who are now on your list of people that you will refer to, so that there can be, as it were, a three-way debate, a debate between IBCA, the Cabinet Office, and lawyers for the infected and affected, not just a two-way debate between IBCA and the Cabinet Office.
Well, if I may say so, I confess that until it was drawn to my attention, I hadn't seen this email before yesterday. I mean, it strikes me reading this that this was an attempt by the claims manager or through the claims manager to explain the reason for a government policy. Now, it seems to me that's a matter we should be able to relay if that's what we've been told. I have to say, in my recommendations I made after the engagement in June and July, a lot of them were about encouraging the government to explain the reasons for lying behind the various contentious policies. And this would strike me as being potentially an aspect of that. Now, the extent to which that should end up on our website or someone else's, I think, is possibly a matter of discussion. But I agree with you that we need to distinguish between what is, as it were, a relayed, reported government view, an explanation about a policy, and something that IBCA for itself is thinking about in legal terms, about an interpretation as to how we're going to apply those regulations. Because they can and probably usually are two different things.
Well, can we move then, and thank you for that, can we move then to what is precisely an example of the latter, which is an issue in the regulations. It's RLIT 00002944, page 88. and it's Schedule 1 to the regulations. RLIT 00029444. It's entirely conceivable I've typed that out wrong now. Page 88 it should be. So if we can just zoom in on level 3, so these are the infection severity levels for hepatitis B and C. And it's item number 1, cirrhosis characterised by serious scarring, fibrosis of the liver caused by long-term liver damage caused by infection. Now, again, it has been flagged up to me by recognised legal representatives that there may be an inconsistent approach that they are experiencing from different claims managers about how to apply that definition. And certainly in terms of my own reading of it, I read this as being the statutory definition of hepatitis of level 3 is serious scarring fibrosis of the liver caused by long-term liver damage. In other words, you don't need to look for something that says cirrhosis in the medical records because you're told that what you're looking for is serious scarring fibrosis. And I've been told there may have been either a change or difference of approach between different claims managers in relation to that. Is that something you can throw any light on, Mr. Foley?
So I'd be very interested in understanding if there's differences of interpretation between claims managers. I'm not sure I've seen that, but this is. You're right. This is the statutory definition, and then it's how do you interpret what serious scarring is. There was a recommendation from the expert panel about what levels would constitute serious scarring, and there are 2 medical indices, I'm afraid their names escape me at the moment, which also give indications about where they're scarring. This is where the advice of a clinical assessor is so important. This is not something that a claims manager will be easily able to interpret or decide on, and this is where they would seek the advice of a clinical assessor to say where on those scales is an appropriate place to draw the definition. And I believe there is some, there are different opinions about where on those scales they should be drawn within the medical professional as well.
It may be said that the bracketed, and I don't want to get into obviously too much by way of what is ultimately, I suppose, a matter of law, but it may be said the bracketed word fibrosis is your statutory definition of serious scarring. Whatever the accurate position, if there are discussions going on within IBCA involving the claims manager or involving any external sources of clinical or other input, looking at different levels or indicators, would you agree that that is absolutely something that must involve discussions, at the very least, with the recognised legal representatives on the panels of lawyers that have been contracted by the Cabinet Office to assist individuals, and that must be something that's made publicly available? Because it would be wholly unacceptable for IBCA to go away and say, well, we're only going to accept level X, and if there may be a respectable view that level X is not the right place to draw the line, and people need to be able to contribute to that debate openly and transparently. Because level 2, that makes a huge difference to the value of somebody's claim, a huge difference.
I would welcome a discussion with the representatives of people so that they can provide input to that, yes.
Let me just ask, you say in your evidence, in answer to the questions you've just been asked, that this would be not a matter for a claims manager, but to a clinical assessor. But what we're talking about is the meaning of a statute. And a clinical assessor is not a lawyer, he's not a drafter, he's not a judge deciding what the statute means, he's just a clinical assessor. How is the clinical assessor to know whether he's looking for cirrhosis or fibrosis or serious scarring? What approach is he to take without himself or herself interpreting the regulations? And is that appropriate that a clinical assessor, particularly if, as you tell us earlier, I think you didn't answer the question whether the clinical assessor was a hepatologist. I think you rather indicated your current clinical assessor isn't. But how are they going to be able to interpret?
So if it's cirrhosis, I don't think there's any interpretation needed. I think that would automatically be there.
Sorry, you're a bit far away from
Sorry,
the microphone.
so if it's cirrhosis, I don't think there is interpretation needed. I think that would be deemed as in this level. If it's fibrosis, then I think it's for the clinical assessor to advise as to whether they think that constitutes serious scarring.
So you start with what the definition means, which is plainly the starting point, and if that involves a judgment, then the question is whose judgment it is.
And it's in terms of does it constitute serious scarring, the claims manager would rely on the clinician to advise on that point.
Thank you.
I've got one further discrete question I want to ask, and then, conscious as I am of the time, I want to then take the break so that people can suggest questions to me before we come back for the final session. So it's a discrete question again about the cohort of infected who are unregistered and have never been registered with a scheme. And it's the question of interim payments to them. I know it's something that's been raised directly with the authority, and I'm not going to go into the detail of some of the interactions or meetings or communications I understand that you've had. What I do want to understand is does IBCA consider that it has the power within the regulations to make interim payments to individuals within that cohort who obviously it was satisfied were eligible, or not? Is that something in IBCA's control?
I don't know. That's what we're exploring at the moment to see if that is feasible and possible.
So again, is that something that you can endeavour to give an update when you can of the time when you will be able to give that answer?
Yes, we can, yes.
So as I say, that broadly covers the topics I was proposing to raise with these witnesses. We could go on probably all day, but we've got an important witness to be heard this afternoon. So if we could take a break now for core participants to suggest further questions that they want me to consider putting to the witnesses.
And you'd like to take the break now before lunch, would you?
I think so. I think it would, if it's not too much of an inconvenience for everyone, I'm hoping that, and I know my time estimate yesterday was completely off, but I'm hoping 20 minutes, and I don't expect when we come back to be longer than probably about 10 minutes. Famous last words perhaps, but I hope I've covered the majority of the broad areas that people have asked me to consider. And I'm very conscious I have an awful lot to cover with Mr. Quillett this afternoon.
Well, we'll take a break until 1:05. That time plainly may be put back should more time be needed. But otherwise, 1:05.
Thank you. So just to say, and as evident by my appalling time estimate, I have had a lot more questions than anticipated. Some of them, whilst being very pertinent questions, maybe questions for the Cabinet Office rather than IBCA, some of them are ones which I think is going to be easier to follow up by way of the inquiry writing to Mr. Foley with some further questions and asking for a further statement. And so I'm going to be asking some of the questions, but all of them will be considered with a little more time than is available currently. So first question, in terms of the cohort that you're currently progressing, so the infected already registered on an existing support scheme. We heard an estimate yesterday of the number, of the size of that cohort. Do you know what the exact size is?
We understand it to be 3,500 and a few more than that. Yeah.
Thank you. Well, again, we may ask you just to confirm that in writing. Thank you. Leaving aside the question of when you're going to start processing affected claims, which I've already asked you about, is IBCA considering the utility of at least opening a register now, so people who are affected can register, send their details in, not yet ready for you to process it, so that IBCA has all that information available when it is then ready to start actually asking people to submit their claims?
We are considering that. There are pros and cons. Would you like me to run through the pros and cons? We haven't made a decision yet, and there are things that we are weighing up. Yeah.
I have also been reminded that there are, of course, people affected who are already registered with schemes, some because they're receiving support payments, some because they're receiving psychological support.
Indeed. Yeah.
Will IBCA be doing a calculator for the supplementary route?
We are working on a calculator for the supplementary route. It is, as you can imagine, much more complicated in terms of doing that, but we are working on that. Yeah.
I've been asked to ask you why you need evidence of the date of diagnosis, to which I understand the answer is because the regulations tell you that's a mandatory matter in the regulations and a matter I'm going to ask Mr. Quinault about. But I'm asked to ask you this. With reference to, in particular, issues about missing or incomplete records, would IBCA be able to do its work more quickly and effectively if instead of date of diagnosis, IBCA was required to look for date of exposure? In other words, would you support perhaps a change in the regulations, not in your gift clearly, but would it be something that you would favour?
Could I take that away and consider it and
Yes.
write back? Yes, thank you.
What is the specialism of the current one clinical assessor?
I will need to find out. I'll write you.
Right, thank you. Again, I'm afraid I'll add that to my ever-growing list of questions I'm going to be drafting for you tomorrow, Mr. Foley, for a further Rule 9. So, Robert, as you've already mentioned, your view was that affected claims should pass to the estate, and the inquiry, as you've rightly pointed out, took a different view. There is now obviously the question of how long it may take for claims to be processed, and a number of people have asked that this issue be looked at again by the Cabinet Office because it's not in IBCA's gift. But would you support, given in particular now what you know as chair of IBCA about how long it's going to take for claims to be processed, would you personally support a change in those regulations?
Well, I think all I can safely say is that my view as expressed when I initially reported on that has not changed. I think it would also be fair to say, having seen the Brown's report, that there are clearly arguments both ways, and that's exactly where, of course, there is a matter of policy to be decided and priority. And I think, therefore, from my present position, that's about as far as I think I can go.
Well, I think that sufficiently, your first point sufficiently answers the question that I was asked to ask. Do questions of the likelihood of and this is probably for you, Mr. Foley, of the likelihood of a transfusion having taken place at a particular time or in connection with a particular intervention get referred to clinical assessors? So in helping establish eligibility, for example?
Yes, they can do. They can do. Sorry, just reading through these.
In relation to the internal review that you've described being, or the internal checks, sorry, that you described being carried out on to check that the claims manager's process and calculation, is that on the whole file or just the final sum? And I'm just going to read to you what's been put to me, which is evidence of a claims manager advising an applicant and their spouse regarding what would be paid to the spouse in the event of the infected applicant's death, which was very significantly wrong. That is an error that would not come to light in considering the final figure would only emerge on the death of the applicant. So it's a slightly complicated way of putting it, but what is the nature of the check? Do you just look at what the sum is, or do you look more broadly at what's been said to the applicant?
Could I confirm? My understanding is it is a re-look at the entirety of the claim. It's not a just was the final calculation correct. But if it's okay, I'll confirm
absolutely.
that.
Is there any data about whether particular claims take longer than others? And if so, why?
Yeah, I don't think we yet have that data that would be statistically significant. We do know from the cases that we have processed so far the sort of characteristics that make for longer cases. In particular, the component part that elongates it is when we need to go somewhere else for information, and that is usually the longest part.
Could I just add to that, because it's not only in this field that I come across it. We as an organisation have a statutory power to require information. I think our experience has been that as things stand, practitioners, busy practitioners in the National Health Service or busy administrators don't necessarily give this the priority that we would like, and we are seeking, and that's no criticism of them because we all know what pressure the NHS is under. But we are engaging with the Department of Health into whether some more clear guidance can be given to practitioners to assist us in the way that we've asked.
This is now a completely separate topic. The inquiry heard yesterday evidence about the Department of Health making an offer of funding a few days ago to 3 of the charities involved in advocacy work. We know there are a number of other organisations and groups and charities that provide assistance in this area, some of whom have limited, if any, funding. Does IBCA have any role in funding such organisations?
Not that I'm aware of. No, this was not, as it were, part of the budget I mentioned. Could I say, however, because it's a good opportunity to say, that we value very much the assistance we get from a wide range of organisations, and we certainly engage regularly with about over 30 of them. And these are people who really go the extra mile to assist those they represent, and we appreciate that very much.
This is an issue that's been raised in relation to approaches to haemophilia centres for information. And if I may just read the question out. So it's understood that claims managers make attempts to obtain the relevant evidence before they approach the infected person about their claim, which means that they are spending time seeking information that the infected person, whether or not represented, may have at their fingertips. As part of this process, it appears that in some cases they are contacting haemophilia centres for information. And that may be unnecessary if the individual has that information at their fingertips. Is that something that you're aware of or can cast any light on?
So we have an ongoing organisational relationship with the network of haemophilia centres, and we're working about what is the best approach for transferring information. The starting point for the claims manager is the information that is held on the infected blood support schemes, and then we will work with the individual who's making the claim as to whether there are other information that we should gather. So we know the haemophilia centres are important. We are working with them at an organisational level, not a claims manager level, about how we transfer information. But the starting point for the claim is what is held on the infected blood support schemes.
And a follow-up, which from the same source, is an understanding that there may be requests going to haemophilia centres which are unnecessary or inappropriate, in the sense that then they're requests for things which either won't exist or won't assist in answering the statutory questions. And the concern is that those are requests being formulated in the mind of the claims manager, who isn't a clinician, and whether there's any process whereby the claims manager perhaps should be checking with the clinical assessor, is this a sensible piece of information to seek from a haemophilia centre, before sending an unnecessary request to the haemophilia centre?
I will check in if that is indeed the case. Certainly, we've got, a very clear relationship between it's not our claims manager, it's our data team and the centres of haemophilia to see what is the best way to request and accept information, and we would only want to do it where necessary. But I'll check in to see if that's the case.
And has consideration been given to, in the very first instance, asking the individual if they're aware whether the required information is available? Because it may be they are able to say very clearly, I know that information doesn't exist. I've spent the last 15 years trying to get it, and I've been told my records were destroyed in 1999. And because there's a concern that some time may be being spent trying to get something which the individual themselves will know doesn't exist.
I will check. I don't think claims managers spend a long time without the individual's guidance looking at haemophilia centre records. As I say, it starts with the data that's held from the infected blood support schemes, but I'll go away and check if that's the case.
And then this is another question which you may need to go away and check. It's about the clinical assessor. Does the clinical assessor, or will the clinical assessor, have in mind, when considering issues such as the likely sequence of events in terms of the progression of disease, will they bear in mind practices, including record-keeping practices, in place at the time, rather than making a judgment based upon current clinical and record-keeping practices?
Yes, they should do. That's certainly the way we have organised ourselves. That's the ethos upon which we have built it. So they should be taking that into account, yes.
Given the current test and learn phase, is consideration being given to setting up a regular opportunity for IBCA to engage in discussions with or receive feedback from RLRs regarding the process?
Yes, consideration is being given, and I understand we are in preparing what would be the right forum for that to be.
Last question. So I am told that there's been a change in the way in which, or what is being provided in terms of EIBSS files, so support schemes files. I'm afraid I don't know if this only relates to the English infected blood support scheme or more widely. I am told that previously complete files were sent from the claims manager to the, this is the case of a represented applicant, the applicant or their recognised legal representative. But now claims managers are only sending selected documents, and claimants have to make a subject access request for the complete file, which obviously then takes time. Is that your understanding, and if so, why is that policy changed?
I would be surprised if they had to, but I will check if that's the case.
Thank you. So those are the questions I'm proposing to ask. As I say, quite a lot of them are ones that I do want to take away, think about, and see whether we ask Mr. Foley to address in writing. Thank you.
Well, I've just two questions to ask you, Mr. Foley. The first is this. You told us that your recruitment rate was 40 every fortnight.
It is going forward, yes.
How many people who you have recruited are no longer with you? In other words, what's the rate at which you're losing staff?
So in terms of claims managers, of those we have recruited, we've only had any attrition from those that were in the first cohort. And in that first cohort, we had an expedited process, and then we had to then subsequently do a full competition, a full interview for them to get through. And in there we did, I'm afraid I can't remember exactly how many, but we did lose less than 10. I can't remember the exact number. The others have stayed with us so far.
And what do you anticipate your loss rate will be going forward?
So many organisations work on the basis of churn being about 7.5%. I suspect for us it will be a lot lower than 7.5% at the beginning, because obviously your front end, people are joining, you don't expect people to leave immediately. So I would anticipate it will be something more than 0 and something less than 7.5%.
Now the second question is this. Council, in one of her questions to you, pointed out the length of time there had been since Sir Robert was invited to make his report on compensation and did so, and the current position, which is that there have been 106 claims paid. And she described that as shockingly low. Now, there was more to the question, but you didn't come back and say, no, I don't agree. Do I take it that you do agree that that rate, given the timescale that she mentioned, was indeed shockingly low?
It's shockingly low in the context of the question, which was 3.5 years since Sir Robert reported.
So the answer is yes.
In terms of the work we have done since May, I think that is a substantial achievement. And it's the result of a lot of hard work from a lot of dedicated people. It is not enough. We know we have to go faster. We know we have to do more. But from a standing start in May, when there was literally just the two of us, I had a laptop and I had a mobile phone, and that was it. We have had to build an independent body. We've had to build a system. We've had to interpret the regulations when they've come in. The first set of regulations came in August. In less than 2 months from there, we started the first claims. In less than 4 months, we paid the first people. We said we would start 250 claims by the end of March. We have started 250 claims by the end of March. We've now written to 677 people to begin their claims. It is not enough, and it will not be enough until every single person is paid compensation. But from a standing start in May, the people who work for IBCO and work for you have strained every sinew and pulled every muscle to be able to try and get to this. And that is a significant development from there.
Thank you. I've no further questions. I don't know if anything arises out of those questions.
There isn't, save to offer both witnesses the opportunity to say anything further they want to. And I think Sir Robert certainly wanted to say something. I don't know if Mr. Foley does as well.
I've got a few words,
Yes.
if that's okay. So I think I'll start with where I finished on that last point. Is we absolutely know, understand, and respect that you are all due compensation, and you have fought for the recognition that compensation gives for such a long time, and it cannot be. It's got to be done faster, and we're trying to do it as fast as we can. I'd like to pay tribute to everybody who has helped us to get to where we have. We've had, as I said, nearly 200 meetings with a vast array of people. People from Haemophilia Society, from hepatitis groups, from the Scottish Infected Blood Forum, from those who went to Trelaws. The list is extraordinary, and those who were misdiagnosed, we went to Northern Ireland. But I want to give one example of the reason all of those meetings were important is the type of moment which makes us realise how important it is to do this. And I remember one meeting with a group of people who represented carers, and I remember one of you telling us in very matter-of-fact terms about the pain and the guilt that this scandal has caused you. And what I wanted to say is that has really stayed with us. Every single person in IBCA, I and everybody who works in IBCA, and I want to pay tribute and thanks to those people who help us to train and induct everybody who comes to work for IBCA. That is what matters to us, and that is what that we care about. So I know it's not fast enough, and I know it needs to go faster, but because of that, we are doing everything we can to go as fast and as far as we can. Thank you for listening to us.
Sir, members of the community, I'm acutely aware that any time taken to receive and process claims and to pay awards is too long for those who have waited decades for justice and in far too many cases have died before receiving it. I've listened yesterday, as I have at so many meetings with members of the community, to their descriptions of the terrible impact the waiting and the uncertainty has had and continues to have on their lives. My heart goes out to them. Throughout, we have been open with the community and conduct a continuous dialogue with them about how we're processing claims. We do listen to the concerns, and what we do is always informed by them. We cannot always satisfy those concerns, but we will be honest about what we're doing and will avoid the risk of raising expectations we cannot fulfill. We do not expect the community to be satisfied with our work until we have made full awards to all those entitled to them, and I can assure you IBCA will not rest until that is achieved. We will continue to review our work, all the time asking ourselves how we can go faster while maintaining accuracy, compassion, and fairness. All our staff are committed to this task. We are committed to keeping you, the community, up to date on our plans and will always listen to your concerns about anything we propose and, of course, to any recommendations you may make to us. Thank you.
Well, can I thank you both for your evidence this morning. It will, I think, have resulted in people having, in this short space of time, become much better informed about the way in which IBCA has worked. And some of it has been quite revealing. Thank you very much for that. You are, of course, since you spent yesterday watching or listening to what was happening here, you are, of course, very welcome to stay here and circulate if you wish and listen to this afternoon's events as they happen. But we will take our break now and we'll take the hour for lunch, but can we just make it an hour and no longer? Because you have a lot of material to cover, I think, with Mr. Quinault.
I do. It will be a long afternoon, so apologies in advance.